Well, good morning, everyone. Welcome back to those of you who were here yesterday, or welcome if you're here for the first time today. I think we're still going to have some people coming in, so yep. So I'm going to have to keep an eye on the list and admit people every now and again. But let's get started. So, can everyone hear me? Okay. Yes. Good. Okay. So let me share the presentation. Okay, here we go. So yesterday, I need to keep an eye on the participants list. Okay. So yesterday we looked at topics 1 through 4. Today we will be discussing what is basically a bridge to all the other substantive discussions which we're going to have on day 3, 4, and 5. And today is very much about the second part of the title of this workshop, where hopefully by the end of the day you will understand what I mean when I say that we might be watching a revolution of civil law throughout the member states, brought about by, to some extent, antitrust law and the rules on private enforcement of antitrust law. And I want to explain to you today why I think that is happening, why I think that will happen in the future. And that's topics 5 and 6. Sorry, that's topic 5 fundamentally. Once you have understood what I meant by that, I think it'll be more interesting for you to have the discussions that we're going to have on the 13th, 14th, and 15th, because then you will realize that we're talking not only about things that are important for antitrust, but about things that can be important in general for other areas of the law in the future. We will also be discussing which issues are governed by EU and by national law, and this is probably one of the most important topics to discuss throughout this whole workshop, and it's probably one of the most far-reaching lessons that we can take from the private enforcement of antitrust today, and that requires really a change of minds, a change in perspective by national jurists in the EU today. We will also look at the primacy of EU law and limits thereof. And finally, I will give you a very short introduction to the trucks cartel, because we will be using the trucks cartel as a case study for all the future analysis that we will do of specific topics. Now, again, for people who are here for the first time, there are some rules of conduct, and I won't go over them all again, but I would emphasize that I really welcome participation. So please do participate during the class through the chat function. Send me your questions in writing, and I will read them out and reply to them. And if need be, I will call on you to provide further clarifications. Also, if there's any technical issue, please let me know immediately. Something that I forgot to mention in the previous class, and that I will now stress, is that I am recording the workshop, and I hope to have permission from the law school to divulge this workshop later on for other people who would like to listen to it. That being said, therefore, if for privacy reasons, if you do not wish your image to appear, most of you are not going to appear, because what's on screen is the presentation. Only 2 or 3 images appear. But if you do not wish your image to appear or your voice to appear, then please do not turn on your microphone or your camera. Okay. Before we get started, remember yesterday we were talking about state aid, private enforcement, and after I finished the class, I went to do my usual rounds of what's new. And lo and behold, yesterday a new case was announced. So cases that go before the European Court are published periodically in the official journal. And a new filing before the General Court was announced yesterday. I'm not going to try to read that name, but in case T9220. And it's a really interesting case because, as far as I know, it is the first time that somebody is suing the European Commission for damages deriving from an authorization of state aid, which this company thinks was unlawful. That state aid should not have been authorized. And therefore, it is saying that the Commission acted illegally, and in so doing, it caused damages to it because it gave a competitive advantage to its competitors. And therefore, it is suing the Commission for over 4 million euros in damages. And that is interesting because yesterday, when I went through the list of possible things that could happen in private enforcement, I didn't list suing the European Commission. I listed suing the member states. And because it never happened, I just didn't remember that, of course, you can sue the European Commission as well in a tort action, not before the national courts because they don't have jurisdiction, but before the General Court of the European Union. So it's really interesting how, the imagination, the imagination of academics never goes quite as far as real life. Okay. So let's move on to the right to damages and the birth of EU civil law. And feel free to cut in at any moment with questions and comments. As you may know, there has for a long time been a discussion at EU level about the creation of a European civil code, and there have been drafts of what a European civil code might look like. That's been going on for a long time because it seems obvious to everyone that the lack of harmonious civil law rules throughout the member states is an impediment to the good functioning of the internal market, and it prevents the complete integration and even movement of persons. But certainly in trade, it is an impediment. And so there have been many attempts to arrive at some kind of harmonization or uniformization of civil law throughout the EU. But also, as you know, these attempts have been mostly unsuccessful, but not entirely unsuccessful. There has been some degree of harmonization, as we will also discuss. The reality is that unto this day, civil law and civil procedural law remains an issue governed by national law. And EU law recognizes the principle of procedural autonomy when it comes to member states deciding how their, specifically in what interests us, how their court proceedings will take place. And you cannot find within the EU treaty any power that specifically allows the European Union to adopt legislation uniformizing or harmonizing civil law or civil procedural law. There is no specific legal basis to do that. That being said, there are several ways in which the EU law can lead to changes in national civil law or civil procedural law, and that's what we're going to be looking at right now. So, how can this happen? It can happen in two ways, through the legislator or through the court. The legislator, and of course when we say legislator at the EU level, we're talking about the Parliament and the Council. And don't forget that the Council is, for those, especially for those of you outside of Europe, the Council of Ministers of the European Union is a meeting of the member states, and it requires almost always a qualified majority for the issues that we're discussing here, which means that it is possible for some member states to be against the rule, and yet it is imposed upon them as EU legislation. And so one of the ways is for the legislator to decide that certain provisions are necessary in order to guarantee the good pursuit of European Union policies, and especially in order to ensure the effectiveness of EU law. So This would happen, for example, the European Union has provisions allowing it to adopt legislation concerning the internal market, and it would regulate certain issues within, to facilitate the internal market, so within that chapter. But in doing so, it would say, well, in order for these provisions to be necessary, we need to set up some rules here that obviously fall within the realm of civil law and civil procedural law. And that is fine, because the way that case law has looked at the competence of the European Union, it has said that the EU is competent to adopt any rules which are necessary to ensure the effectiveness of the European policies it is pursuing, and of the European Union rules that it does have the competence to adopt. The idea is relatively simple, and there is a great example of that in case C-17603, where basically there was a dispute about whether the European Union could force member states to adopt criminal provisions. And obviously some member states were not in favor of that, and they said criminal law is our prerogative. We didn't transfer sovereignty to the EU to decide on criminal law. And the court said, that's right, you didn't, but you did this transfer sovereignty to decide on environmental policy. That was what was being discussed in that case, in that directive. And in order to pursue this environmental policy, it is absolutely indispensable to have criminal provisions backing up these prohibitions, because if you don't, they will be deprived of their effectiveness. And so the two go hand in hand. It would be a void, an empty, a toothless directive if they just required you to impose certain restrictions, but then they weren't backed up with criminal sanctions. So we do the test of proportionality, and if we arrive at the conclusion that criminal sanctions are necessary for the effectiveness of those rules, then the EU has the competence to adopt them. So that is one way in which we arrive at several documents, several legislation that allows and that actually pursues the harmonization or the uniformization of civil law and civil procedural law. The other way, of course, is for the European Court to interpret EU primary law and EU secondary law, and to interpret it in a way that leads to harmonization or even to uniformization, as we will see. Of course, uniformization will always be theoretical up to a point, because in practice there will always be heterogeneity. It's unavoidable when the rules are created through case law. Uniformization will always be a goal and not really a guaranteed result. So how does the court's case law harmonize national civil law and national civil procedural law? So we're first looking at harmonization, and then we will look at uniformization. Two very different approaches. In harmonization, we start from the recognition that the issues in question are governed by national law. Okay? And then we say, okay, fine, but even if this issue is governed by national law, if you are using your national law to enforce EU law, or if your national law is going to affect rights which are granted to persons by the EU legal order, then your national law is subject to limits by EU law. It's subject to a test by EU law. Your national law cannot be such that it deprives European law of its effectiveness. Right? There's also another restriction, which is that it cannot violate the principle of equivalence, which means that you cannot treat your own rights more favorably than you treat the rights of your country, more favorably than you treat the rights deriving from the legal order of the European Union. This in practice is very extremely rare, so I will focus just on the principle of effectiveness. That's basically the equivalence is basically an expression of the principle of non-discrimination according to nationality. Now, this position of the court might sound surprising, and we're going to see that it is incredibly far-reaching and it has extraordinary consequences. However, it really is an absolutely necessary consequence of the direct applicability of EU regulations and of the direct effect of the provisions of directives and of the treaty. You cannot have direct applicability and direct effect. You cannot have primacy of EU law without having some measure of control over whether the national law, which is used to apply EU law, actually guarantees its effectiveness. Because otherwise, member states would be entirely free to basically deprive EU law of its reality and practice. People would not have access to rights that are granted to them by EU law because they are forced to litigate those rights in national courts, and the national courts would be applying law that completely deprives them of their effectiveness. So we understand the need for this limit imposed by EU law, but sometimes what this leads to may be surprising. And I would point out that we're not talking about something new. This goes back to really some of the most important historical cases of EU case law. The most obvious example is Cimental, C-10677. Of course, this theory of harmonization was primarily developed for procedural law issues, because the whole idea is, and it's very connected to the recognition of the principle of procedural autonomy by member states. That being said, it also applies to substantive law. And I don't want to get too far into this argument, but there is a significant problem here, which is that nobody really agrees on what procedural law and substantive law is. So let's not get too bogged down in this, because it's going to be a fruitless discussion. What some countries consider procedural law, others consider substantive. Within the same countries, there are disputes about whether certain rules are substantive, certain rules are procedural. So let's not put too much emphasis on the idea of whether the national rules subject to the principle of effectiveness are procedural or substantive. That doesn't really matter. What matters is if those rules are being used to enforce EU rights, right? To enforce EU law. And if that is true, then this limit will apply. This principle of effectiveness will function as a limit, regardless of whether or not you qualify them as substantive or procedural. What is the bottom line? We're still within harmonization. What is the bottom line implication of all this case law concerning the principle of effectiveness? Well, ultimately, EU law will impose this effectiveness test on all national rules related to the enforcement of EU law, which, if you think about it, really can be basically everything. Any provision of the Civil Procedural Code or the civil law of the Civil Code, any provision that can theoretically be used to argue rights that derive from the EU legal order or obligations that derive from the EU legal order in a national court is subject to this control of effectiveness. And this is really alien to the way that we think, especially in continental Europe. It really requires a complete change in the way that our courts think. I don't believe that it is. I personally love this approach, and I think that our national courts should do this approach themselves under national law. But it is not our culture, it is not our history, it is not our tradition. I think that, I can only talk about Portuguese constitutional law. I would certainly say that the principle of effectiveness is also a principle of the Portuguese legal order. And yet, I have never seen well, that's not true. I can think of a few examples, but it is extremely rare that a Portuguese court would invoke the principle of effectiveness in the same way, with the same result, as the European Court of Justice does. Our courts are usually very positivist. right? They stick to the letter of the law. If the letter of the law leads to an unfair result or a result that is not really in accordance with the general principles and values of the legal order, well, you know, it's the law. Of course, I'm exaggerating. There's control of constitutionality. There's control of fundamental rights. Of course, there is. But it's just taken to a completely different level with this principle of effectiveness by the European Court. So the principle means that whenever a court is confronted with a certain rule, and don't forget, this control has to be done by every single court in the European Union. So it's not just the Court of Justice is going to say, does the principle of effectiveness require you to change your national rules? Every national court that is applying national law within the context of EU law, within the context of enforcing EU law, they have to control this, whether the principle of effectiveness is being complied with. And so they have to ask questions like, does this rule make sense? Does it lead to the result that our legal order wants to achieve? Is it compatible with the principles and values of our legal order? If it doesn't, the solution will have to be set aside, and the court has to impose a solution that does guarantee the effectiveness of the rights. It's such a simple idea, but it has endless revolutionary potential. Because when you look at the history of the case law of the court and the application of this principle of effectiveness in controlling national law, you see time and time again examples of national rules that go before the Court of Justice. And the national legal order has been living with those rules, you know, with no problem for years, decades sometimes. And they accept those rules as being perfectly fine with the values of their legal orders, with their fundamental rights. And then all of a sudden, the European Court looks at it and says, well, but that makes no sense. The principle has no effectiveness like that. You know, famously, a British case, you cannot have provisional measures against the state. Well, wait a minute, that doesn't make any sense. I mean, if you can't have provisional measures against the state, and there is periculum in mora, there is fumus boni iuris, how are you going to guarantee access to justice? How are you going to guarantee that at the end of the case, the rights are still useful to enforce, that there's still anything to protect? That's the whole point of allowing provisional measures. Why wouldn't you allow them against the state? You're depriving the rights of effectiveness. And so the European Court tells the UK, your prohibition of provisional measures against the state makes no sense. And the UK has to change their national laws, at least in what concerns the enforcement of EU law. And this kind of rationale, you might think, well, why didn't the national courts come to the same conclusion without without needing the intervention of the European Court of Justice? That is a long discussion, but the point is they didn't, right? And we have this time and time and time again. And then we have the other path, not harmonization, but uniformization. Uniformization is quite different. Here, the court, instead of saying that the issue is governed by national law, the court decides that the issue is governed directly by European Union law. And not because there has been European Union law adopted by the legislator governing that issue, but because the court looks at usually primary EU law and general principles, but not necessarily. The court looks at EU law and says, wait a minute, there is a right here which is being awarded by EU law, or an obligation. And if there is a right or an obligation which is being awarded to persons by EU law, that means that the conditions for those rights have to be defined by EU law. They cannot be left up to national law to decide when there is a right, when there isn't. That's a matter of EU law. When there is an obligation, when there isn't. If it's an obligation of EU law decides when there is an obligation. It's that simple. And don't forget that sometimes even the right itself has been created by the court. You know, this is the obvious expression of direct effect of provisions of the treaty, for example, internal market provisions that are addressed to member states, saying they cannot impose restrictions, and it's just that the provision itself only sets up an obligation to the state, but the case law tells us that that means that there is a reflexive right of the individuals to not have restrictions imposed upon them. And so sometimes even the right itself is not in the letter of the law, but the court creates it, and then the court will clarify the conditions to benefit from those rights and how they may be applicable. A notorious example of the uniformization of civil law and civil procedural law through case law, although calling it civil law here will be highly debatable because it falls a little bit within the confines of public law. But in any case, it was the creation of the tort liability of member states for infringements of EU law. And key cases there were Frankovic and Brasserie du Pêcheur. So basically, there was no provision in the treaty saying that member states, as a matter of EU law, had to pay compensation to individuals when they caused damages deriving from their infringements of European law. But the court said, yeah, of course there has to be. There has to be, and that right is not a right that is granted by national legal orders. That right is granted by the EU. And so it's the EU that is going to tell you, the subjects of law, what the conditions for those rights are. Because of course, each member state had its own requisites for when the state would be liable to people for its actions as a legislator, as an administrator. And the court said, no. When there's an infringement of EU law, the requirements are set out in EU law, right? And of course, another example of this is the one that we're looking at in this course, the right to damages for infringements of EU antitrust law and of EU competition law more broadly. It's the exact same situation. And in fact, the case law of the court, which is now developing this right to damages for antitrust infringements, that case law is being clearly inspired in the case law of the court on member state tort liability. Some things are not exactly analogous, but to the extent that there is analogy, the court is clearly going to that case law for inspiration. So first you create this right. You say that this right derives from the EU legal order. But the next thing you need to do is to clarify, okay, so what are the conditions of those rights under EU law? Because the legislator hasn't said what it is. And there, basically the court has to put flesh on the bones on a case-by-case basis. So every new referral to the European Court will give us a little bit more of an idea of how exactly this right exists, what exactly are its conditions. And this case-by-case approach is complicated because EU law is not common law. Right? It doesn't function as common law. We don't have the rule of precedent in the European Union legal order, even though in practice we kind of do, because of the principle of sincere cooperation. Under the principle of sincere cooperation, if an issue of EU law has already been interpreted by the ECJ, national courts are required to interpret it in the same way. However, this is not a rule of precedent, and we as continental lawyers, well, except for the people from the UK and Ireland, we look at the case law of the European Union in a very different way than you would look at common law. And this leads to some very unfortunate differences that create problems sometimes. For example, there really isn't in our minds, there isn't a difference between obiter dictums and ratio decidendis in EU case law. The most infamous example of why this becomes a problem is the Dassonville judgment, right, in internal market, which then led to Keck of the court for the only time in its life having to say, yeah, we got it wrong, we're now changing the case law. It changed the case law other times, it just didn't admit that it was doing so, and in Keck it actually felt that it needed to be clear about that. And that happened precisely because we don't distinguish between an obiter dictum and a ratio decidendi. We like our abstract general definitions. And the court is tempted to give abstract general definitions of concepts and rules, right? And in so doing, and it's probably going to do this when it approaches liability. It's already started doing that. It'll give abstract general rules while looking at individual cases. Now, in common law, the reason why only the ratio decidendi is binding is that the court isn't thinking of every possible situation when it looks at a case. So it shouldn't really be coming up with abstract rules. It's coming up with the right solution for the circumstances of that case. And that's what's binding in the future. Not some kind of abstract general statement that wasn't necessarily fully considered because not all scenarios were being considered, right? So there is a big complication there. Sorry, I have some questions here to address. Somebody said the existence of the subjective right in itself is a Praetorian creation. They were quoting me. What do you mean by this? I mean that sometimes this was a reference to the fact that sometimes a subjective right is not set out in the treaty or in EU law itself, but it is created as a reflexive right from an obligation which is set out in the treaty. Okay? So, for example, the right to damages under antitrust law is not set out in Article 101 or 102. Article 101 or 102 says companies cannot form cartels, they cannot abuse dominant positions, etc. And then the case law comes in and says, well, this implies that there is a subjective right, right? So then you have a subjective right of Praetorian creation, the horizontal direct effect in that case. And someone else asks, isn't it too intrusive in national civil law principles of each country to have a definition of their civil obligations and rights defined by the EU? Well, yeah, I don't think it's too intrusive, but that is certainly the political discussion that we are having throughout this class, and that people are having elsewhere as well. So we will certainly be discussing precisely that idea, whether or not you consider it too intrusive, and some lawyers, some judges do consider it too intrusive. And someone else asks, is there a connection between the sincere cooperation and the German Constitutional Court's decision not to follow the ECJ's ruling? Well, I will get back to this today, actually, but in any case, well, it was a violation of the duty of sincere cooperation. Not just of that one, there were other rules that were infringed, but obviously it was also a violation of the duty of sincere cooperation. Okay. So just to wrap up this idea, so the reason why I'm trying to call your attention to the distinction between the way the rule of precedent works in the EU and the way it actually works in common law systems is that the implications of this will be that as we move forward, fleshing out the bones of liability for antitrust infringements, you're going to have general statements that will be, for example, Skanska, which we will talk about, is a good example of that. You're going to have general statements that are not necessary for the resolution of that case, but those general statements will be incredibly useful for future cases, and they will be deemed binding, whereas without much discussion, whereas in common law systems, there would be a lot of discussion. There would be a lot of discussion about whether the ratio decidendi really included those statements or not. Okay, so moving on. How might EU law and antitrust enforcement lead to the birth of EU civil law? I would summarize this in a few possibilities. I think that those who are now working with antitrust private enforcement, they're being faced with very innovative, very effectiveness promoting solutions put forward by the directive and put forward by the case law. And they're looking at those solutions, they're contrasting them with the ones in national law, and there is an obvious difference. And so I think that one possibility is that the European Union legislator itself is going to put some of those solutions in directives of other areas of the law. And some of these debates you have already creeped into, for example, the proposed directive on consumer collective redress, which in many ways already takes several steps forward in a few of the discussions that were had in the damages directive. And if you're interested in this topic, this proposal is another example of the extent to which the EU legislator is moving forward to harmonize EU civil procedural law. Then there is another possibility, which is that the court itself will extend the principles that it is now affirming and the lessons that it is now drawing to other areas of the law. And I was supposed to give there an example, but I forgot. There is, memory now eludes me, but there is a very recent case filed, I think, 6 or 7 months ago, where I don't remember the exact area of the law. I think it was regulatory law, but basically somebody was looking at the antitrust private enforcement case law and asking, hey, does this also apply to this area of the law? I mean, they weren't saying it as such, but basically they were asking the same question. And so already lawyers are looking at antitrust and saying, but wait a minute, that same logic applies here as well. And they're trying to extend those lessons to other areas through case law. I think that the fact that we are going to have a greater number of high-profile cases, such as the trucks cartel, for example, which we will be discussing, will bring to light, will shed light onto the problems of this heterogeneity, and it will probably create some public pressure, at least pressure from the legal system, from the practitioners. It'll probably create public pressure for a broader harmonization and uniformization at EU level. When people start seeing that, people in one country have, they're compensated for damages and people in other countries are not, and why is that happening? And this will not be easy to accept. So there will be pressure for greater harmonization at EU level, or even greater harmonization at national level. Because national legislators might be facing democratic pressure to change their laws to guarantee that their citizens and their companies can defend their rights effectively in court. And then there is another factor, which is that usually, not usually, always, when these requirements of EU law, only apply, of course, when EU law is applicable. So for example, in antitrust, if you have a rule in the directive or a rule in the case law, that rule is only going to be applicable if Article 101 or Article 102 are applicable, if there is an effect on trade between member states. If the infringement is exclusively an infringement of national competition law, then this protection, these rules of EU law, the principle of effectiveness, etc., none of that applies. And so theoretically, you could have a two-level system whereby you have a different degree of protection for purely internal situations than you have for situations with a connection to the EU legal order. But that just doesn't happen because that's not acceptable in a democratic society, right? You cannot have, I mean, it might happen temporarily, but it's just not acceptable that depending on which legal order your right comes from, one of them is better protected than the other, right? And so, for example, when Portugal had to change its national law on the liability of the state because of the Francowitt-Pratrit-Pêcheur case law, we didn't just change it for the situations when EU law was being infringed, we changed it for all situations, right? So case law fostered a drastic change in the Portuguese and other member states' rules on state liability far beyond what the court could actually impose, because the national legislator could not allow for this kind of discrepancy depending on which legal order created the right. And we saw the same thing in the damages directive. The damages directive, courts, member states were technically free to say, well, these rules only apply when 101 or 102 are applicable, but they didn't. Every single country said this will also be applicable when just national competition law is applicable, right? They weren't required to do so, but of course they did so. And finally, national legislators might be tempted to turn sectoral solutions into general ones. So, for example, in Spain, during the transposition of the directive, the experts who were drafting it said, well, these access rules, they're really interesting. Why don't we just put this in the general rules of civil procedure instead of creating this special solution. And then the government didn't want that, so it didn't go forward. But that's the kind of debate that we will have in the future. Someone asks, bearing in mind the principle of primacy of European Union, is there actually the need to change the national rules? EU law will be applicable anyway, right? No, so EU law would not be applicable. So for example, if you're talking about civil procedural rules, it's the national rules that are applicable. I think what you might be thinking of is a situation where if the national law has not been changed, the national court will have to adapt national law to conform with primacy and effectiveness, and that is absolutely true. But generally speaking, it's not. You obviously do need to change national law, otherwise it's a disaster for legal certainty, and you might say it's a violation of the principle of sincere cooperation. But very complex question. I'm sorry, I have to reply to it very swiftly. Someone else asks about the proposed directive on consumer collective redress, which excludes competition law. Thank you so much for that point. This is one of the most shocking aspects of the proposed directive. So let me be clear. We know that consumer redress does not exist in EU law at the EU level. There are very few cases of mass damages for consumers in every area of the law, not just in antitrust, in every area of the law. So the European Union legislator is intervening, trying to create mechanisms to make it easier for consumers to be compensated, right? Which is great, but it puts a list of tens and tens of documents of EU law that are included in the scope of this new mechanism, and it leaves out antitrust for reasons that are absolutely incomprehensible, especially because antitrust is the most obvious field where gigantic mass damages claims could be brought and are not. So the question was, how comfortable are you? And the answer is, I'm not comfortable at all, and I don't understand what our legislators are doing. But of course, I come from a country where this is not a problem because we have a great opt-out law, so our consumers can be protected. But in other countries, that doesn't happen, and that's the whole point of EU intervention. So I do hope that the European Parliament will look at this, certainly not the Council, but that the European Parliament will look at this and realize that there is no reason to exclude antitrust from the scope of that directive. And someone else says, what would hinder the national legislators from deeming EU rights better than national rights? It would be strange, I admit, but not banned at least. No, absolutely, it's not banned. So national EU law does not prohibit that you treat your own national law and your own national citizens worse than you treat people from other EU countries. So you're entirely free to do that. Nothing would hinder them whatsoever. It's just that politically, from my experience, this has been untenable. And so they do tend to not, as you say, to not be able to defend that at home politically. Okay, getting a lot of questions today. Does the damages directive prompt forum shopping? Is it possible at all? I wouldn't say it prompts forum shopping. I would say it didn't, although this was one of the goals, it definitely didn't stop forum shopping, and we do have forum shopping. We do have companies, and we'll talk about this in the context of the trucks cartel, but we do have the plaintiffs deciding, I'm going to litigate in that country, not in this one, because it's more favorable to me, to my interests. And we do have defendants using the Italian torpedo technique, not just in Italy, by the way, in other countries as well, to file negative declaratory actions, also in an expression of forum shopping. Okay, so the bottom line, I would say, is that antitrust private enforcement is forcing member states to look at their laws and in many cases conclude that specific rules are just not good enough. We're going to see a great example of that in the Cogeco case, which will be discussed tomorrow. And the question then becomes, if this rule is not good enough for antitrust, why is it good enough for other areas of the law? If we've had to drastically change our rules on access to evidence for antitrust, Why is it that our rules, our general rules on access to evidence are good enough as they are? Surely something is up here. And this is a debate that is not spreading as quickly as one might think, because unfortunately the study of the law is very segmented, and we're all very specialized. So it's really only antitrust specialists, and then the litigation experts that are now working hand in hand with them. These are the ones that really become aware and familiar with this new law and this new case law. And so it's going to take some time until these lessons trickle down to people who are specialized in other areas, and then that they fully disseminate throughout those fields of knowledge, and that people will say, well, maybe we should be changing general rules, or we should be changing the rules for this area of the law as well. I've already been answering a lot of questions, but of course, if you have questions at this point before I move on to chapter 6, feel free. Because now we're going to be discussing something fundamental. Which issues are governed by EU and by national law? Okay, I will proceed. Before we really get into this, this is a good moment to give you a very important preliminary issue, which is that the court does not think about antitrust private enforcement like private people think about it, and like competition authorities think about it. There has been a tendency to look at private enforcement as a private interest. And the court doesn't look at it like that. It says private enforcement is also in the public interest. It is a crucial tool which helps the community as a whole ensure that competition law is being complied with, and ensure that the goals of the European Union's competition policy, and even beyond, even the internal market, etc., that these goals will be achieved. This is a common logic of the court when it looks at private enforcement in other areas. It thinks, private enforcement is basically a free decentralization of public enforcement. Why should we entrust our administration with the burden of making sure that laws are complied with? Use the market. Let people's selfish economic interests work in our favor as guardians of EU law. And it's a great strategy. It has worked very well for the EU in the past. And so it has been applied by the court also to the realm of private enforcement of antitrust. So the court wants to protect the effectiveness of private enforcement because it knows that in so doing, it is protecting the effectiveness of competition law and competition policy as a whole, right? And this has consequences. For example, I think that if you look at Skanska, you find this kind of reflection in the part where the court is justifying why it was going to interpret Undertaking, so who is liable, in the same way in public enforcement and in private enforcement. It goes into this analysis. Precisely because it is looking at private enforcement as a tool to also strengthen public enforcement. So if that is so, it makes sense that concepts are interpreted harmoniously in both fields. And I've given you a list of cases that go over this idea. The Damages Directive itself expresses this idea. In the next slides, I will not be mentioning the cases because it would take up too much space. But I want you to know that in the next slides, for every single issue that I will be mentioning, there will be those examples, and they're not going to be exhaustive lists, but those examples are there because there is specific case law that has already said so. Okay. All right. So, which issues are governed by EU law and national law? But before I get into that, I have, I'm going to go back because I have a question. How does this public interest aspect of private enforcement relate to the thought in Antitrust Damages Directive where the goal of the right to damages is primarily to ensure compensation? The Damages Directive actually says that it's not. You look at recitals 1 and 3, the public interest goal is expressed there. It's the selfish economic interest thing. Of course, you use the right to damages as a hook to give people a reason to spend resources on enforcement of competition law. but that is also in the public interest. But I think I agree with your point that you know, there is still, from the legislator's side, there is still too much focus on thinking about ensuring compensation and not just about protecting competition law as a whole. Okay, so this issue is kind of complicated, how to separate. Remember, we talked about the difference between case law that does harmonization and the difference between case law that does uniformization. And that's exactly what we're talking about here, okay? And there were brilliant opinions by Advocate Generals Cocotte and Val, and they were the ones who really codified this first in a doctrinal approach, which was then taken up by the court. So whenever a party seeks damages based on an infringement of Article 101 or 102, the rules on what Cocotte called constitutive conditions, I think it was her, rules on constitutive conditions of rights and obligations, those are governed by EU law. So that's the issue of what does a right exist, what are its conditions, what is its scope. So you're asking questions such as who has a right, what right, when, under which conditions. These questions are answered by EU law. They are not answered by national law. National law has no role to play here, unless you are talking about enforcing right to damages from infringements of national competition law. Be careful, because whenever EU law is applicable, national law will also be applicable, which means that technically you will have potential primacy issues, because you are going to say, well, you know, national law still applies to my rights under national competition law, and then EU law applies to my rights under to the determination of whether I have a right for the infringement of EU competition law. The solutions might be different, but of course the court will be compelled to respect the primacy of the rights under EU law. If you don't have a right under national law, so be it, but you definitely have a right under EU law for the infringement of EU competition law. Well, you definitely, well, if you do have a right, then the court cannot say no, because under national law you wouldn't have that right. So one are the constitutive conditions, and then the other group is rules that concern how the rights are exercised, or how someone defends against the exercise of those rights. And this is what is governed by national law. The question here is how. How do we exercise and enforce these rights and obligations, right? And whereas the first group, the law is set out entirely by EU law, and there's an interesting reflection about Advocate General Val, he's now a judge, about the level to which in this area the case law has to pursue full effectiveness. There's an interesting discussion about that, but it's EU law. Whereas in the exercise of the rights, you're talking about national law subject, as we said before, to the limits of equivalence and effectiveness. And this is true before and after the directive, okay? So don't think that, oh, now we have a directive and we apply the directive. No, 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 these discussions continue to apply, not just because of issues of temporal succession of laws, but also because even after the damages directive, some issues are not regulated in the directive, so they will be continued to be controlled by the limits of effectiveness and equivalence. And the directive itself might infringe effectiveness and equivalence. Theoretically, we cannot exclude that to be the case. And of course, the other way that these rules on the exercise of rights have been affected by EU law is that they have been subject to harmonization by the damages directive. Right. One footnote there, although the case law has still not discussed whether this is true for state aid and merger control rules, I think that obviously it has to be. If there is a right, we already know that there is a right deriving from state aid rules, the right to damages. We can assume that the same is true for merger control, and therefore the same distinction of what is governed by EU law and what is governed by national law will also be applicable in those two fields. This is just for your records. So where is this set out? This is not entirely an exhaustive description, but it is more or less exhaustive. This is the case law that I use to arrive at the conclusion for this segmentation. You will find underlined what I consider to be the turning points in the clarity of the case law. As you can see, there were two very important opinions of advocate generals that really set out the doctrine of thought on this, and then in Skanska, the court took it on, and then in the most recent Otis judgment, it continued that line. So it has now been accepted, in my opinion, into the case law quite clearly, this distinction, but it was initially proposed by advocate generals. Oh, and by the way, initially proposed by Advocate General Van Gerven back in the 90s. So he was really, really ahead of his time. Okay, but now let's go deeper into what is in each of these categories. When we talk about the constitutive conditions, what are they? Well, again, every single thing that is here has been clarified by case law, and there are specific cases to back this up. The requirements of the existence of the right are determined by EU law. And EU law tells us that the requirements are free. There must be an unlawful behavior, there must be damage, there must be causality. Now, those of you from civil law countries will see that there is no reference of fault here. The reason for that is that in EU law, fault is subsumed into the analysis of the unlawful behavior. The unlawful behavior in EU law does not require fault per se. Well, actually, it does require fault, but it doesn't require the behavior can be negligent. It doesn't require guilt. The behavior can be negligent. And in order to determine that there has been an unlawful behavior, you have already determined that there was fault, and therefore it's not autonomized as a requisite for the existence of a right to damages. But it is, in a way, included there. And then for causality, you have had really a very non-demanding test set up in the two big cases that have discussed causality, as we have already mentioned. And then you have the existence of the scope, the existence and scope of liability of undertakings. Who is responsible for what, right? And this is, of course, what was discussed in Skanska. Is a parent company liable for the behavior of the subsidiary? Is the subsidiary liable for the behaviors of the parent company? Is a successor undertaking responsible for the behavior of the undertaking that has succeeded, etc., etc. And within this issue of the scope of liability of undertakings, we also include restrictions to that liability and the conditions of joint and several liability. Joint and several liability is also imposed by EU law. We're talking here about the members of cartels fundamentally. The quantum of damages, the quantification of damages, how much one is entitled to, that is also determined by EU law. What are the types of damages which may be compensated? You know, the court has told us very clearly, damnum emergens has to be compensated, but also lucrum cessans has to be compensated. Loss of profit. We also know that interest is determined by EU law. Now, there is still room for debate there, because there might be some margin for national law to come in and give its own solutions, but those solutions will be subsidiary is not the right word. Those solutions might be valid as general solutions or solutions in principle, but it must be possible, in my view, for the undertaking, for the claimant, to prove that it is entitled to a certain interest which is different from I'm blanking out on the term in English, from the general rule applicable in national law. So, for example, if you have a rule on late interest that says that, as in Portugal, you get 4% interest after the payment is due, the court would say probably, I think, that, well, that is an issue of EU law, but if you say in Portuguese law that 4% interest generally would be applicable, that's okay, as long as the party can prove that, in fact, its damages were higher, or as long so that it is entitled to higher interest, or as long as the other side can prove that the damages were lower and that the party is entitled to lower interest. And there is no right to overcompensation. This is very important. So the whole basis of how much, just like in, I think in every member state legislation, the basic idea for how much damage you're entitled, how much damages you are entitled to is, it's the principle of full compensation and not overcompensation. The causes for exclusion and limitation of liability are also regulated by EU law. Contributive fault, venire contra factum proprio, those kinds of things, the extent to which they are allowed and will be affecting the damages you are entitled to, that's determined by EU law. So what does this leave for the other rules, the rules that are determined by national law? Now here, this is most definitely not an exhaustive enumeration. This is the enumeration that we can find from case law. These are the examples that we already have. We know that, and the first two, they're difficult to, there's a border which I think once you understand it, it's clear, but it's not obvious when you're reading the case law. So be very careful in the first two. We say that the quantum of damages is determined by EU law, but then the case law tells us that the methodology to quantify damages is determined by national law. What does that mean? How do you reconcile those two? I think the easiest way to understand it is to say that you're not discussing here how much you are entitled to, but how are you going to go about determining that in a very specific case, right? Which is fundamentally a procedural discussion. So you know as a matter of law that you are entitled to this, this, and that, but then in the specific case, you have to look at the facts and determine exactly how much that person is entitled to. That is a procedural matter, and of course, it will be up to the national law within the limits of effectiveness. The same thing goes for the methodology for assessing the causality. So, for example, EU law tells us that you are entitled to umbrella effects. Okay, to umbrella damages. If the cartel led to general price increase in the market, you can argue that even though you were not a client of the cartel members, you were affected by the cartel and you are entitled to damages. But then it's up to the national law to say, again, how are we going to determine if this is so, right? How is this assessment going to be made? So that's how I would draw the frontier there between when discussing quantification and when discussing causality, the border between what is governed by EU law and what is governed by national law. Then you have the issue of which courts within the member state have jurisdiction. That is also determined by national law, but of course within the limits set by EU private international law. The limitation period, but the limitation period has now been largely harmonized by the directive. The rules on access to evidence, but again, now they have been largely harmonized by the directive. Evidentiary rules and presumptions, also harmonized by the directive to some extent, but a lot is still left to the member states to decide. And finally, whether to allow or not punitive damages, this is a historical point. In the past, this was possible, but now with the directive, it is no longer possible. The directive has prohibited this. So for the future, even the few countries in the EU which did allow punitive damages, they can no longer do so in the scope of antitrust damages. And that's it. So it's very complicated issue. It's probably one of the most important chapters. So if you have questions, feel free. I think somebody wrote me. Okay, I have one question. What if a member state did not implement the part on interest? So there is nothing to implement in concerning interest. There is a great study coordinated by Professor Giorgio Monti at the European University Institute in Florence. If you're interested in that discussion, please do check out that study. It has national reports, and it sets out very clearly the chaos and the legal uncertainty, not just comparing one state to the other, but also within each state about what interest you're entitled to. My argument is that EU law has to determine what interest you're entitled to, and not the member states. It's not that the member states can create rules in their national law to transpose or implement EU law. That's not the issue. the court is going to have to give us the rules on what interest you are entitled to. Alexandra asks, does this mean that state aid would allow for punitive damages? Because you said for antitrust it's not allowed. No, well, yes, I'm going to have to say yes. I think that if the courts were to think about this now, it might go back to its earlier case in Manfredi and think, was this really a good decision? But if we're to apply Manfredi logic to state aid, then yeah, you're right. Countries which allow punitive damages are not forbidden from doing so in state aid. Very, very interesting question that you raised, Alexander. Oh, I have a lot of questions. Let me go back. So Filippo asks, can you explain a bit more the interaction between EU and member state law and the quantification of damages? Well, the idea here is that I can't go into too many details for time, but the basic idea is that how much you are entitled to as a matter of law. So whether you're entitled to the damages directly caused by the damnum emergens and the damages of loss of profit, that is determined by EU law. Whether or not you're entitled to certain interest, certain remuneration of the opportunity cost of the capital which you did not have available during the period in question, those are issues governed by EU law. But national law will tell you how you go about determining exactly in the specific case, looking at the facts of the specific case, how you apply EU law on the right to damages to those specific facts. If you want perhaps an example to understand how what this translates into, if you look at the directive, here I might be confusing the directive and the transposition. I might be confusing the directive with some transposition, but there are many. There is a recommendation that you should use the Commission's guidelines on quantification of damages, and the Commission is required to produce these guidelines to assist the courts in the quantification of damages. That is exactly what I would describe as methodology. So if you look at the Commission's guidelines on quantifying damages, that's methodology. How do you go about quantifying damages? It is not how much you are entitled to as a matter of law, as an abstract discussion. It is how you go about quantifying them in those cases. How do you calculate the surcharge? Do you compare prices in different member states? Do you compare prices before the cartel and after the cartel? All these different methods that economists use. That is a discussion of methodology, for example. Could you please repeat the references of the private enforcement state aid case you mentioned at the beginning of the lesson? I don't know which case you're referring to. Oh, the one that I said that was new. Oh, I don't know the name. But you will receive the PowerPoint presentation that I am using, so you'll be able to check that. Well, or I can just go back now and tell you. It's easier. Yeah, so it was here. It's T9220. T9220. Filippo says, my understanding is that EU law just gives the basis to fine violations, but national law determines a specific quantity a party is entitled, and this can vary a lot per jurisdiction. Yeah, so that's not my reading of the case law. My reading of the case law is that this would be unacceptable for EU law, because then what you're saying is that you do not really have a right to damages under EU law. You have a right to be compensated in ways that are not determined. And then it's up to each state to determine how you have a right to be compensated. And that is unacceptable, because that means that you basically would have a completely different right from one member state to another. And that is not true. The right is not determined by the member state. The right is determined by EU law. So the right has to be the same, regardless of whether you litigate it. And you might not yet have had a discussion about this on quantum, but you have certainly had discussions about this on causality in Cone and in otis, and the court there has clearly said causality is not determined by national law, it's determined by EU law. You've had discussions of this in Skanska. Who is liable, that's not determined by national law, it's determined by EU law. So I apply the same logic to quantification as well. Otherwise, you have a different right depending on which member state you are litigating in. Maria Jose says, as for the member state which allowed punitive damages, that you know where they limited to antitrust, or was that in general? So this was, the question came from the United Kingdom, which historically allows punitive damages, and it was a general characteristic of that legal order. In the USA, you famously have treble damages for antitrust, which is a great tool to incentivize private enforcement. This view that private enforcement is in the public interest, they take it one step further and they say, well, let's give people an extra incentive to help us enforce these rules which are in the public interest. Let's give them treble damages. We don't do that, and quite on the contrary, we prohibit that because we say that the limit is full compensation. Margot says, provided that damages act essentially as an additional fine, in that it imposes an additional pecuniary obligation to the infringer, what about proportionality and necessity of sanctions when both damages and public enforcement fines are applied? I don't agree with your view at all. Damages are not an additional fine. That's not at all what they're meant to achieve. And there is no, when you're determining damages, there is no place whatsoever for the discussion of what fine has already been imposed, because it is completely different discussion. You have a right to be compensated for the damages that unlawful behavior caused you. If you reverse the discussion, then there is space. And in fact, national competition authorities have been invited to consider, and some of them have already incorporated this into their practice. They have been invited to consider reducing fines when infringers agree to compensate their victims. That, as far as I know, that never happened. So there really isn't. There would be room to discuss proportionality there if a company, for example, said, "Well, we have set up a program to compensate our victims. That program is actually working. It's effective, and yet the competition authority did not take that into account." Then there would be a reason to argue in court that should have been a mitigating factor of the fine. But I just don't know any example where that has happened. How does this interact with the findings of infringement by the Commission? I'm not sure, Filippo. I don't understand what your question. Okay, very well. All right. So let's move on to the primacy of EU law and the limits of that primacy. And here I have to give you, because some of you might not be from the European Union, have not studied European Union law before, just a very quick introduction to the primacy of EU law. It's not set up in the treaty. It's not set up in written EU law. It was created by the court, and it continues to be only in case law. There was an attempt at including it in the treaty at the time of the failed project for a constitution for Europe. But then when we gave that up and we moved to the Lisbon Treaty, one of the big things that we dropped was the codification of primacy. So primacy exists, but it exists in the case law, not as a rule of the treaty. And of course, throughout the years, there have been many disputes between the Supreme and Constitutional Courts of these different member states and the European Court. Simon has added something about the limitation period. We will be discussing the issue of limitation period tomorrow, and in fact with guests from the Netherlands, Simon. So you will be able to have those discussions in that context. So just to this topic is worthy of many doctoral theses, and I'm putting it into one slide. But the basic idea here is that after the dispute with the German Constitutional Court that ended in Solange 2, I don't know how to read that, I'm sorry. there was a kind of negotiated piece. That negotiated piece said whereby constitutional courts, supreme courts of member states, and doctrine said, yeah, there is primacy of EU law, but there is a limit. The fundamental principles of member states' legal orders must be complied with, and constitutional courts, supreme courts, they believed to have the right to control whether EU law respected those fundamental principles, and therefore they could invoke the limits to the primacy of EU law if the necessity arose. The Court of Justice has never accepted this, I mean, explicitly at least, and it's really very complicated. It's not that simple because there are issues of EU exclusive competences where it becomes really complicated to say that you've transferred your sovereign competence to supranational authority, and yet you can control the use of those authorities, even though the treaty says that only the court can control it, the European Court can control. So there are really very complicated discussions that I cannot go into right now. But you know, these discussions are not in the past, and if you followed the news from last week, you know that. First of all, there was recently a really big problem with the cases of Tarico 1 and 2 coming from Italy. Basically, it was a discussion on limitation periods, by the way, in a criminal matter, and you know, to describe the case very shortly and unfairly. Essentially, what happened was that there was first a referral from a lower court, and the ECJ said, well, you know, the Italian limitation period in this case is depriving EU law of its effectiveness. What happens in practice is that it's always time barred, and that doesn't work. So it's not effective. You cannot impose this rule. You have to grant a longer limitation period. And then the Italian Constitutional Court looked at that ruling when the case went up, and it said, you know, we're not comfortable with this because this is criminal law. There are fundamental rights at play here, and we think that you can't really impose retroactively an extension of the limitation period. Now, that is a big discussion because this is not retroactive. The limitation period was already illegal before, and so under the principle of effectiveness, you know. But then again, people didn't really know that. Private citizens didn't really know that. So it's a very complicated discussion. And the Italian Constitutional Court fundamentally sent an ultimatum to Luxembourg, and it said with a new referral in the same case, in the same question that had already been discussed, and it basically said, hey, change your mind about this, or we're invoking the limits to the primacy of EU law. And the first case had been discussed in the Grand Chamber. The second case was discussed in the Grand Chamber, and the court changed its mind. And it came up with a very sophisticated face-saving solution, which found a solution apparently within the EU legal order and EU fundamental rights. But the bottom line is, it received an ultimatum, and there was a dialogue with the Italian Constitutional Court, and it changed its mind. It allowed the Constitutional Court to adopt the decision that it wanted to adopt. Contrast that with what happened now with the German Constitutional Court, right, where there was a confirmation by the European Court that the European Central Bank decision was valid. The European Court is the only court that has the competence to control the validity of European Central Bank decisions, and yet you have now had a judgment of the German Constitutional Court saying, we disagree. We think that the ECJ judgment was arbitrary and not duly reasoned, and we're going to invoke, fundamentally that's the idea, we're going to invoke the limits of primacy, and we're not going to be considered bound by that judgment. And of course, the European Commission is now pressured to open infringement proceedings against Germany because this is really, it's not entirely unheard of in the history of the EU, but it is a particularly shocking example. Another problem that we're having with primacy has to do with the Polish and Hungarian legislative reforms, where you're having open judgment, very openly critical judgments of the European Court saying you're violating fundamental principles, you're violating fundamental rights, and you need to change your laws. And with Polish government, Hungarian government being very resistant to that and trying to find ways basically not to respect the primacy of EU law and to say that you know, they don't have to comply with those judgments. So these discussions never go away. So why are we talking about primacy here? What's the point? Well, the reason why we're doing this is because several of the solutions that have been included in the directive have kicked up a hornet's nest of protests by, I have to say, mostly non-antitrust practitioners. And certainly, well, of course, there's always a big division between the lawyers who defend the plaintiffs and lawyers who defend the claimants. There are a few likely suspects amongst the directive. And though I've chosen the ones that, the three ones that I think are going to attract the most attention, but there are others. The first is the binding effect of NCA decisions. The reason this is complicated is that in many member states, for example, in Portugal is an extreme example of this. Not even court judgments are binding on other courts, and I'm not talking about a rule of precedent. That's not it. We certainly cannot have a rule of precedent, and we even have a constitutional a judgment of the Constitutional Court saying there cannot be a decision of the Supreme Court that binds lower courts to interpret law in that way in the future. So not even that, okay? But we can't even have, for example, if you're accused of murder and a criminal court convicts you of murder, and then somebody has a parallel civil case, the civil court is not bound by the decision of the criminal court, even if it's res judicata. So we're really very radical about this. Even in this, within this framework of the same case, the same facts, the same people, you can never have one court being bound by a decision of another unless there is a hierarchical relation and you're within the same case, right, an appeal. And therefore, for a country such as Portugal, the idea that a competition authority decision, an administrative authority's decision, would be binding on a court is even, more absurd. Don't forget that sometimes NCA decisions are subject to judicial review, so the thing that will be binding is the court judgment, not the original decision, or the decision to the extent that it is confirmed by the court judge. But in any case, this has been really target of much criticism because it infringes access to justice, because it infringes the fundamental principle of independence of the judges, etc., etc. Now, I find this discussion really odd because we have had master foods and we have had Regulation 1/2003 for a long time, and nobody said, as far as I know, nobody argued, this goes against fundamental rights, this goes against fundamental principles of the Portuguese legal order. Fine, we didn't really have a lot of discussions on this in Portugal, not a lot of opportunities, but even in other countries, I'm not aware of that argument being made. So this is one of the issues where you're likely to see the lawyers for defendants saying that there is a violation of fundamental principles of our legal order and invoking a limit to the primacy of EU law. I think in practice that will have an impact because it's a delay tactic, but in practice, it's not likely to change the outcome of a case because even without that, the persuasive effect of decisions is very significant, but it could. The other issue, which is a likely suspect, is limitation periods. Limitation periods have, as you have already heard, have been at the source of discussions about primacy, and they will continue to be because of the impact that they have on legal certainty. And it is something that is always litigated because it is the first thing that in any antitrust damages action, the defendant will say. I can assure you, if you're acting for the defendants, you know that you're going to invoke the limitation period even before you look at the facts of the case. You don't need to know the facts of the case to know that you're going to argue limitation. It's going to be in. And limitation is always discussed, tends to be discussed very much near the beginning of the case. And so it brings up many opportunities for this to be litigated. The other issue is the liability of the undertaking. People are going to say that there is a principle of personal responsibility, that principle is limited to legal personality, that you cannot ascribe liability to a different legal entity than the one that carried the behavior, except in very restricted scenarios. This, of course, varies from member state to member state, but some countries, such as Portugal, are have a very restrictive approach to this. Germany as well, for example. So this will also be discussed. It's not as obvious a discussion as binding effect of decisions, because it's not entirely clear to what extent there really is a fundamental principle of the legal order that is here at stake. But it will be discussed. And then, of course, you will have discussions on other fundamental rights, or the same fundamental rights, not because of the rules themselves, but because of the way the rules have been applied in a specific case. And people will argue that they have, both from the claimant and the defendant side, they will argue that there have been infringements of fundamental rights. So you're going to have a lot of opportunities to discuss fundamental rights in antitrust private enforcement. I'm talking a lot about fundamental rights because basically when you're talking about limits to primacy, that's what you're usually discussing. You're going to have to come up with some kind of fundamental right that has been infringed, and this creates a problem. When I said that there was peace, that there was a kind of a peaceful solution arrived at between the ECJ and the Constitutional Court of Germany and Italy, etc., that peace derives from the fact that if you're talking about infringements of fundamental rights, if that's the test for invoking the limits to the primacy of EU law, what happens is that this doesn't really occur, right? I mean, you know, Tarico was an example of where the Italian constitutional court put its foot down and say, oh, we have a problem. And then notice that the solution in Tarico was for the ECJ to identify a violation of EU fundamental rights, right? So the scope, you know, the likelihood that a constitutional court would say, or a Supreme Court or whatever would say, this violates a fundamental right, and the ECJ says, no, it doesn't, the likelihood of that is small, okay? You're already drastically reducing the scope for potential conflict. Especially because the fundamental rights are the same, basically. Most in terms of the ones that are really problematic, constitutions and the European Charter of Fundamental Rights set out basically the same fundamental rights, and we're all bound to the European Convention on Human Rights, which is interpreted by the European Court of Human Rights. And so there's kind of a harmony of fundamental rights throughout the EU. So these conflicts shouldn't occur. When they do occur, they occur because there is a different interpretation of a fundamental right? Right? Not because the fundamental right itself is different, but because its implications are being interpreted differently by the courts, which means that these disputes are limited to really, really tiny gray areas. And it also means that the ECHR, the European Court of Human Rights, can play kind of a mediating role here, because if it's just a dispute of interpretation, and if you have the ECHR saying that, well, under the convention, this should be interpreted this way, at least for over-expansive interpretations, this will kind of limit them. It doesn't prevent the constitutional courts from saying, well, if the ECHR wants to say that this is not forbidden under the if the European Court of Human Rights wants to say that this is not forbidden under the ECHR, that's their problem. Under our constitution, it is. They can do that. Of course, they can do that. But you know, it's kind of, if you have the ECJ saying there's no fundamental rights problem, if you have the ECHR saying there's no fundamental rights problem, and the constitutional court says yes, there is, I can think of one constitutional court that has the nerve to do that, but not many would. And in my view, the scenarios where these limits to primacy might actually be invoked will turn on, first of all, the prevalence of formalism and positivism over a functionalist approach. The political choices of the judiciary, and I don't mean the politicization of justice is not what I'm saying. I'm saying that, you know, as individuals, as humans, of course, our views of the law are guided by our political positions, our positions on policy and how society should be. And of course, that's going to translate into how the judges vote. There's a reason why decisions of Supreme Courts and constitutional courts are not unanimous. You know, even though we're supposed to have a scientific method in interpreting the law, of course, we disagree about how that should be, and much of that disagreement has to do with different political approaches. But also this role of the ECHR, which I'm hoping that it will diminish the potential for conflict between the national courts and the ECJ. Raquel is asking, perhaps this question will be answered, but since the directive does not allow retroactive application, to what extent is it possible to justify an interpretation that is in line with the EU's primacy over evidence, taking into account the purpose that the directive aims to protect? Miguel, I'm not sure. We're going to have a chance to discuss access to evidence further on. So I would ask that you bring this subject up in that day, okay? Because I didn't entirely understand the scope of the question right now. Okay, so these potential diverging interpretations of fundamental rights, they are a risk. There is a possibility that some court will draw a line in the sand. However, when it comes to the national court judgments, there will be an appeal. There will be an appeal to the ECHR, and the ECHR can have the final word. Of course, it depends on whether you're talking about a positive or negative scenario. So basically, if a fundamental right has been disprotected, the ECHR can protect it. The opposite is not true. If a fundamental right has been protected under the interpretation of national constitutional law, the ECHR cannot say that they can't do that. But there is also an avenue for dialogue and harmony between the national courts and the Court of Justice. And I set this out here as an adventurous, possibly academic approach, but I think that I really think that this has a basis in law. If a Supreme and a Constitutional Court looks at the primacy of EU law and says, that's fine, but in this case, we have reasons to invoke the limits to it because there are infringements of fundamental rights. I think that in those cases, they're going to have to make a referral to the court, to the European Court. And here's why. The argument might be, the Constitutional Court might frame its argument simply as saying that rule of EU law infringes our Constitution, right? This fundamental right of our Constitution. That might be the argument. But because the same fundamental right exists in the EU legal order, it is necessarily implicit in that argument that the Constitutional Court thinks that the fundamental right in the EU legal order should also mean that the EU rule infringes EU fundamental rights, right? Because the fundamental rights are the same, and especially if we're interpreting the ECHR, if the fundamental rights are the same, it's a really formalistic thing to say, no, we're not interpreting EU fundamental rights, we're just interpreting national rights. Hey, they're the same. If they're the same, it means that you do suspect that there is also a problem with EU fundamental rights. In that case, I would say that the Frost case law, plus the principle of sincere cooperation, requires them to first give the Court of Justice a chance to look at it from the EU law perspective and to determine if the EU rule is invalid for violating fundamental rights, right? And if they do that, the court will look at it, it'll give its opinion, and of course the Constitutional Court can disagree. But there will be dialogue, and this will reduce the scope for the possibility of clashes. Okay, so I have a few other questions here. Maria Jose says, when I identify binding effect as a potential issue to the validity of the damages directive, are you implying the validity of that specific rule of the damages directive? Are you implying the irrefutable presumption could be judged as evidentiary matter, hence procedural, thus autonomy of the member state? No, I am saying that that's not the issue. It is definitely an issue that is governed by national law, but harmonized by EU law. What I'm saying is that if the harmonization has infringed fundamental rights, then the rule of the directive would be invalid, right? If it goes too far, then the harmonization would not be valid. So it's not really a discussion, as I see it, of whether or not that the binding effect is a substantive or a procedural issue, because we know, regardless, remember what I said a while ago, regardless of that qualification, we know that the EU law is treating this as a matter governed by national law and harmonized or subject to limits of effectiveness by EU law. Okay, and I will now move on to giving you a small introduction to the trucks cartel. This is really a preparation for tomorrow's lecture and the lectures of the next days, because we're going to be using the cartel, the trucks cartel case as an anchor for our reasoning about the different legal issues we will be debating. We will be using it as a case study. So I want you to become a little more familiar with the facts of the case so that we know what we're talking about. So that's the reference to the case. It was a decision, in fact, 2 decisions by the European Commission. There was a first decision that concerned almost all of the members of the cartel except one, because this was the decision where everybody settled. So everyone but Scania settled, and these are basically, they're virtually all, they have almost 100% of the market share, 90-something percent of the market share of trucks in Europe, all of them put together. And in the first group, we had leniency and settlement. So if you look, one of them had immunity, 3 of them had reductions, and except for the one that had immunity that paid no fine, everybody else also got another reduction for settlement. Okay, what does that mean? That means that this first decision is a decision that was everybody who is the addressee of this decision confessed the existence of the infringement, and they got to negotiate the contents of the decision to some extent with the European Commission. You find that as you read the decision, you find that the negotiations on the content of the decision were probably less of a factor in this case than in others. You then have a second decision for the company that did not settle. That one came later, and that was just for Scania. So keep in mind, it's the same infringement. There's joint and several liability, but one of the members of the cartel has a separate decision, and that member of the cartel is still appealing that decision. We're going to see that. So one decision is everybody confessed the infringement, etc., and it's become res judicata. The other decision for the same cartel with joint and several liability is not res judicata, and it's still being disputed whether or not the infringement occurred. I love the trucks cartel case because it gives us so many examples of the complications that can arise in the context of antitrust litigation. The total fines applied were very, very high. So even with the immunity for man, you have, and the significant reductions, 60%, 40%, 30%, you've had drastic fines of 3,000 million euros almost in the first decision, and then 880 million euros in the second. Now, these figures might seem very high, but only the trucks manufacturers know the truth. But it has been estimated that all the actions for damages that have been filed following on these decisions, that they will vastly surpass the amount of the fines. So where we're talking about 3.8 billions in fines, and it is estimated that there have been at least over 10,000 million claims and damages. Okay. No one knows the real figure. It's going to take many years until the figure is known, but judging from the amount of cases that have been filed and the few figures that have been known, we would say that it's going to be at least triple the amounts of the fine. The practice itself related to medium and heavy trucks. It covered the entire European Economic Area, and it lasted for 14 years. So it's gigantic. And notice the period. Notice the period. The decisions we're litigating this now in 2020. The first cases were filed in 2018, but the infringement ended in 2011. And this is something I want you guys to keep in mind. Antitrust cases take a long time. The infringements usually last for a long time, especially for cartels. And then it takes a long time to litigate them in public enforcement. It takes a long time to litigate them in private enforcement. And this creates huge evidentiary hurdles. It's very difficult to, some of the evidence going back to 1997 might not be available anymore. Do you still have the invoices to the trucks that you bought in 1997? This is incredibly complicated. And the principle of effectiveness makes it even more complicated. Like, what happens if you don't have these invoices? You're supposed to have an effective right to damages. How are you going to, is there a way that you can demand something less than the invoice, some kind of indirect evidence or something, so that you protect the effectiveness of the right to damages? So the temporal factor is always a huge concern in antitrust damages cases, not just because of the limitation period, but also because of access to evidence and other such considerations. The practices themselves were collusive arrangements. By the way, this is a highly controversial thing. I'm involved as counsel in some of these cases, so I don't want to take sides here. This is a description taken from the press release of the European Commission. Okay, the collusive arrangements. There were collusive arrangements on pricing and gross price increases. The companies cooperated on manipulating timing for introduction of emission technologies, and they cooperated on passing on to customers costs of emission technologies. So this was fundamentally what the decision says, according to the press release, and it means that there were price increases. And of course, one of the discussions is, were those price increases passed on to the purchasers, because there were gross price increases. The case started with a leniency application back in September 2010. And then there were dawn raids. And after the dawn raids, there was a rush for submission of other leniency applications. 3 other companies submitted and then got reductions on the basis of leniency. The statement of objections was adopted in November 2014. This is important for the discussions on the limitation period. And the decision itself, the first decision, was adopted in July 2016. But it wasn't made, there was a press release, but the decision itself wasn't public until 6 April 2017. So almost a year later. Very important issue there to keep in mind. This, even worse, the second decision, which has been appealed, is not yet public. It has not, there is no non-confidential version of this decision. Keep in mind that this sometimes happens. You already heard yesterday that companies will do their best to prevent or delay the publicization of decisions. In this case, you have a decision that has still not yet been made public. I think there might be a typo there. I think there might be a typo here on the date of the decision, because this doesn't sound right. The decision is from 2017. I'm sorry. Yeah, decision is from 2017. The case was filed in the appeal was filed in 2017, so the decision is also from 2017. So many years have gone by. Now imagine if this were the case. Imagine if you didn't have a first decision. Imagine if all you had was this decision. It had been appealed. You've had almost 3 years gone, well, 2 years and a half gone by, and still you haven't seen the decision, right? It's this kind of problem that we have to keep in mind then when we discuss the limitation period, especially if the discussion is framed prior to the applicability of the damages directive. And now I just want to give you a little overview of what's happening in different countries and how this case has been pursued. It's interesting that many different strategies have been taken up. It's fascinating to watch the market at play to defend interests, because that was the whole point of the damages directive. Make it easy for people to go to court, and people will go to court, and that's what happened. It's not as easy as people thought it was going to be, or some people thought it was going to be, but what you've seen is, I'll give you the example of Portugal about how companies have decided to go after their compensation. In Portugal, most of the large companies owning trucks, so that they had a big fleets of trucks, they decided to sign up with mass actions, collective actions that have been filed in the Netherlands, right? And they did this in different ways. They do this through the assignment model, or they do this in a more classic collective action model where they're represented by a law firm that brings together all these claimants and they're backed up by litigation funders. There's so many interesting discussions here because, for example, if you're a Portuguese lawyer, internal market problems, if you're a Portuguese lawyer, you cannot go to a company and say, hey, we will litigate this case for you. We will find litigation funding. Don't worry. We'll take care of everything. We'll take care of all of the costs. And in the end, if we win, you give us a share of what you make. Causality. You can't do that in Portugal. You can't do that in many member states. In others, you can. So if a company comes here and says, hey, we'll litigate this, a Dutch law firm, for example, comes and says, we'll litigate this case for you in the Netherlands, and you give us a share of your proceeds at the end if you're successful, there's really not much the Portuguese lawyers can do to compete with that. We can't make a similar offer. So it's interesting that there is somebody was talking about forum shopping. There is lawyer shopping. There is competition between legal services from different member states. So most companies have decided to go to the Netherlands and join these collective actions. There's a big reason for, one of the main reasons for that also is that a lot of companies don't like to sue suppliers with whom they need to have a continuous relationship. So they felt that if they put their cases together in a big lake, they would just be a drop in the bucket and they wouldn't really be noticed. Whereas if they file an individual claim, it attracts more attention. But that was the first wave, and most of the large clients were taken up, most of the large companies that were affected were taken up in that first wave. And then there was a second wave, coming much later, about a year later, where companies started filing cases directly before the competition court. And this was the initiative of a few small law firms in Portugal who are not the main, none of them have like the main antitrust practices in Portugal. They have some antitrust experience, but they were basically full service law firms. And they said, well, here's a chance. Let's do this. No one else is doing it. And they took some cases to court in Portugal. In Spain, oh, sorry, I have some questions. So Miguel is saying, yesterday you said that leniency is a crucial tool for NCAs. True, but if I'm not mistaken, even if you get immunity or reduction in public enforcement, it does not influence your possible liability for damages in private enforcement. Does it? Do you think that strengthening the rights of individuals damaged by a cartel, in fact, lowers motivations for the cartel participants to turn themselves in? It does not affect liability, except in one of the leniency beneficiaries, except in one way. Their joint and several liability is excluded. So they will not be held jointly liable unless everybody else goes bankrupt and can't pay the joint and several liability, and then they become liable. Does it reduce the motivation? Well, it's certainly a dissuasive factor, knowing that you won't get the fine, but you might get sued for damages, especially because the damages will tend to be higher than the fines. Does that mean that we should be protecting leniency applicants more? I don't think so. I don't think they should be. It's one thing to get away with not paying the fine. It's another thing for the state to give up and say people are not entitled to damages. They're not entitled to be compensated for the damages that they suffered because of this cartel, because this person came forward and allowed us to identify the cartel. That's just not fair to me. They won't get the fine, and that's already a huge incentive because they know that they risk being discovered. And what if the claim, Petra asks, what if the claim is assigned, fiduciary assignment, to a vehicle for Causality, which then hires an attorney? Would this work in Portugal? In the field of antitrust, it hasn't been tested yet, but under our general rules, in principle, it would. So if you assign, well, we don't know. So the thing is, if you assign your thing, you would be expected to, there would be expected to be remuneration for your right. So that's basically, and this is something that was discussed now in Germany. If you don't really have if you're not really paying a price, if it's just saying, well, if we win it at the end, we'll pay you a price. If not, nothing. This might put in question the validity of the assignment. So my approach to that would be to say, have a real assignment of a price, even if then you include an added element of a success fee, but have a real price, and then you can hire an attorney and do that. So that would be possible. But again, the attorney himself would not be able to do Quantification, because that is forbidden for the provision of legal services. Right. So so you've had these different models throughout the countries, and different approaches to litigation have come up. I want to point out what happened in the UK, where they're trying to use the opt-out model in the trucks cartel litigation, and that's really interesting. We also have that possibility in Portugal, but it's very new. Nobody has ever tried it. Opt-out for undertakings, and everything is frozen. All these opt-out actions are frozen in the UK while we await Merrick's v. Mastercard's decision of the Supreme Court. But it just goes to show you have countries where one claimant files several actions, one against each trucks manufacturer, and then you have thousands and hundreds of actions in different courts, always at the seat of the defendant, of the claimant, etc. And it disseminates, and it's incredibly burdensome for the judiciary. You have other jurisdictions where, or in parallel, you can have these solutions in parallel, where huge, massive claims are filed as a classic bundling of claimants, or as representative actions, or through the assignment model. And then you have the opt-out model. So you have all these different solutions being rehearsed, and the legal market and the courts are trying their best to handle this very different new reality and to come up with the best way to handle it. Alexandra asks, Michal asks, excuse me, I assume Czech or Slovak background because of your surname. My surname? I'm called Sousa Ferro. That is not Czech or Slovak. Okay. And there has also been, maybe I misunderstood what you're saying there. Aha, okay. Thank you, Miguel. You were talking to someone else. There has been also a case from Hungary, Tibor Trans. Absolutely, we mentioned that, Alexandra. We mentioned that case yesterday. So there has, Tibor Trans basically clarified that you can sue for damages under Brussels regulation. You can sue for damages where the company is based, where it bought the trucks, and that's basically what Tibor Trans came to clarify. And we're really coming up on time. I want to recommend this amazing research for all of you interested in empirical data. I want to recommend the fabulous research that has been carried out by Professor Francisco Marcos on the situation in Spain. Spain really is the most chaotic of the countries right now in terms of the drugs cartel litigation. Professor Marcos has put together really vast, incredibly valuable data about how the different cases are being solved. You already have hundreds and many judgments, so many cases have already ended. And what you can see is a profound heterogeneity in not just in the interpretations of law, but also in the factual outcomes of the cases. You have cases being thrown out because they're filed against a subsidiary and not against the parent company who was the addressee of the decision. And some cases saying, no, subsidiary is part of the economic unit. You have some cases being deemed time-barred and other cases not being deemed time-barred, even though this is an issue of interpretation of law. It's not because the facts were so different. And then you have completely different quantifications of damages, going from no damages to 5% damages, and then all the way up to 21% damages. I'm talking about the surcharge, sorry, saying when I say 21% damages, I mean that the court has calculated that the cartel caused a surcharge of 21% or 5% in the price of the trucks. And this variation is in part explained by the fact that many of the lawyers who put forward these cases were dealing with very small claims, and they didn't really have the capacity, the money, the resources to back them up with economic reports. Whereas other law firms, one in particular, which has filed thousands of cases all over Spain, they have economist reports because they use the economies of scale. And so the courts have looked at that economist report and they said, well, that seems reasonable. And so those are the ones that have been getting very high surcharge fees, estimations around 20%. Others have been getting estimates literally by approximation and guessing. We're going to talk about quantification later. Other times the courts has just said, well, we can't really know, but we have to guess under EU law. We have to estimate somehow. And those are the ones that have usually ended up on 5% or 10% of the surcharge. Okay, just to end, Miguel says, under the damages directive, one would not be able to sue the individual persons responsible for the fine. Would that affect decisively the possibility to sue such persons in the Portuguese court? The damages directive does not, it's not that it says you can't, it just doesn't say anything about it. So it's left up to, you might say that it's left up to national law to decide it, especially because it can't be an issue of EU law, because EU law creates an obligation for undertaking, not for its managers, not for its CEO, for example. There is no obligation for the CEO. So you can't derive a directive subjective, you can't directly derive from the EU law subjective right to damages from the managers. But under national law, such rights may be granted. So it's really going to depend on the national law of each country. I think in the Portuguese law, it is possible. And there has been, if you're interested in that from a Portuguese perspective, there has been a nice paper published on that by a professor from Coimbra, Maria Elizabeth Ramos, which you can read on that topic. And Alexandra says, do you believe this case sets a dark future for private litigation with such different outcomes? No, I don't think this case sets a dark future. I think this case sets a great future because the trucks cartel is showing that private enforcement can work. It's showing us where it doesn't work and why. And we need this. We needed one huge case to shed light on the benefits of the law that we have and on the problems of the law that we have. And I think that that's exactly what this cartel is doing, what this case is doing. And we're learning a lot. And so I think that it's going to be very positive in the end. And that's it for today. I've managed to steal only 1 minute extra of your time. And I thank everybody for attending. And tomorrow we will continue. Thank you so much.
Thank you.
Thank you. Thank you.
Thank you.
Thank you, Miguel.
Thank you.
Thank you very much.